This is Barry Zalma speaking for Claims School Incorporated's blog, Zalma on Insurance. Today we talk about a blue tarp is not roof repair and why roofers, insurance, hurricanes all seem to get together to involve someone in fraud. And the defrauded homeowners by the roofer litigated for years to get a judgment allowing them to have their money back in a case entitled Gary versus Hollier Specialty Roofing, a Louisiana Court of Appeal decision started in December of 2023 and ending sometime late in 2025. In Gary versus Hollier Specialty, Ryan Gary and Rebecca Gary, homeowners who suffered roof damage from Hurricane Delta, sued Hollier Specialty Roofing, Inc., a roofing contractor who took the money the Garys got from their insurance company and refused to complete the repair of the roof, leaving them with nothing but a blue tarp over the holes in their roof. The Garys' roof was damaged by Hurricane Delta on October 9 of 2020. The next day, they signed a written agreement with Hollier Roofing for repairs, including an addendum authorizing direct insurance payments from their insurer, Federal National Insurance Company. Hollier Roofing installed a temporary tarp and received payments totaling $18,278.21. $2,190 from the Garys for the tarp, plus insurance checks of $5,588.88 for the tarp and $10,499.33 for the repairs that were never done. However, no further work was done, and Hollier Roofing submitted escalating estimates up to $22,406 for full roof replacements, leading to an updated insurance approval of $18,224.80. And still the roof wasn't fixed. Frustrated by the lack of progress, the Garys demanded return of unearned funds. In April of 2021, Hollier Roofing partially refunded $6,043.47, but retained $6,645.66, claiming it for overhead profits and services under the agreement. The Garys sued in May of 2021 for declaratory judgment invalidating the contract, unjust enrichment, in violation of Louisiana's Unfair Trade Practices Act, the LUTPA, L-U-T-P-A. On July of 2021, the trial took place on a declaratory action and Hollier Roofing's exception of prematurity, but on March of 2022, judgment invalidated the written contract and overruled the exceptions. April of 2022, Hollier Roofing filed an answer and reconventional demand for breach of contract and LUTPA attorney's fees. In May of 2022, the Garys moved to strike the reconventional demand and for partial summary judgment on unjust enrichment. In June of 2022, Hollier Roofing filed a cross motion for summary judgment and an amended answer demand without leave for the answer portion. The Garys responded with motions to dismiss the amended pleading for sanctions and to compel discovery, and on August 19 of 2022, the court granted Gary's motion to strike the conventional demand, partial summary judgment awarding $6,645.66 for unjust enrichment and sanctions, $1,500 in attorney's fees, and concurrently denied Hollier Roofing's cross motion for summary judgment. But that wasn't enough. On August 31, 2022, the court entered a supplemental judgment granting the Garys' motion to compel discovery and denied Hollier Roofing's motion for leave to amend. Not satisfied, Hollier Roofing appealed both judgments, and Garys answered seeking additional attorney's fees. The Third Circuit Court of Appeal conducted de novo review for summary judgments and abuse of discretion, manifest error for other issues, and held that the Garys' partial summary judgment was reversed, that the Garys' supporting documents, check copies, were unauthenticated, and that genuine issues of material fact remained on unjust enrichment. Dismissal of the cross motion for summary judgment was affirmed, ultimately served under Louisiana Code with no electronic confirmation of delivery. Denial of the cross motion for summary judgment became moot, dismissed as untimely served, and manifest error under the Louisiana Code. There was no bad faith or improper purpose found, and denial of leave to amend was affirmed because there was no abuse. Evidence showed that Hollier Roofing's pattern of bad faith delaying tactics undue prejudice to the Garys, and the Garys' request for additional fees was denied. On August 19, 2022, the judgment as amended was reversed and dismissed. Hollier Roofing's LUTPA attorney fees claim, Garys' partial summary judgment and sanctions attorney fees was affirmed. This case shows that hurricanes are hotbeds for fraud perpetrators. The litigation made clear that the defendant Hollier Roofing acted horribly to the Garys, leaving them with nothing but a blue tarp. They took their money, put a tarp on their roof, and left. The actions were clearly found to be fraudulent, and they deserved judgments against them, but had enough money to take the Garys through litigation for years, from 2020 to 2025, where the opinion finally got a judgment that the Garys can use to get some of their money back if Hollier has funds that can be attached and garnished to the Garys. This video was adapted from my blog, Zalma on Insurance, which is available free to anyone who clicks on the URL zalma.com/blog. You can subscribe to the blog, and if you do, you'll receive notice of every blog posting, usually 5, sometimes 6 a week. And you'll also gain access to the more than 5,200 blog postings. Please tell your friends and colleagues about this blog and these videos so that they too can subscribe. They're free. And if you're interested in further detail about insurance, insurance claims, insurance law, and insurance fraud, please consider for a very small fee subscribing to my Substack publications. Thank you for your attention.